Changing Little Johnny's School, Part 2. Last week we wrote about and had a YouTube video on a recent ruling by the Ontario Court where a judge lamented that each September brings with it a spike in last-minute urgent family law motions brought by separated parents who are in a dispute over where their child should go to school. The court called this pre-Labor Day, let's change Johnny's school, urgent motion, and in a characteristic fashion decried the attempts by the parents and their lawyers to use it strategically to gain advantage in the broader litigation between them. As promised, this week we revisit this ruling to look briefly at the substantive elements of the case, which involved the separated parents of 3 children. Since splitting up in 2013, the parents had negotiated a custody and access agreement, later incorporated into a comprehensive court order, in which they agreed to share custody, but have the children live with the mother. Both parents would still have an equal voice in decision-making on major items, including education. They also committed to working out any differences between them, starting with mediation or collaborative law, and using the court only as a last resort when there was a change in the material circumstances. Both parents had moved on to new partners. The mother had remarried and moved with the children to St. Louis in the United States, where her new spouse lived. The father, who lived in Hamilton, saw the children several times a year, including most of the summer. This summer was no exception, and the children joined the father in Hamilton, and at the end of June 2020 for their annual 7-week visit. However, at the end of August, when they were due to return to the mother's home in St. Louis, the father brought an urgent motion to have the children's custody arrangements changed. Specifically, he wanted them to stay with him in Hamilton and to be registered in school and attend school there. The father claimed that the 3 children all wanted to stay in Hamilton, but the evidence on this point was mixed. He also presented the court with a litany of complaints from the mother. For example, he had noted that he had had a large 5-bedroom home, while the mother in St. Louis had a crowded rental duplex. He also took issue with certain aspects of the mother's care of the children while they were with her, and raised concerns over her approach to COVID-19 safety, especially in light of the higher U.S. infection rates as compared to Canada. After looking at the established legal test for changing a final order relating to custody, the judge wrote the following. The father's materials do not nearly establish the dramatic changes he is asking would be in the best interest of the children, let alone that there is any element of urgency which would justify hurriedly imposing sweeping changes on a temporary basis. To a large extent, the father has simply assembled a collection of issues he has known about for years: homeschooling, dental care, crowded housing, etc. Each of those issues may require consideration, but none of those issues, either individually or together, justify suddenly dramatic upheaval of the children's lives. A parent can't save up a list of complaints over a number of years and then select a self-serving moment to declare an emergency. In a sensitive, lengthy, and contemplative ruling that examined the various factual elements in detail, the judge homed in on what were the father's apparent pandemic-related concerns. The court indicated, number A, that these are good parents, both of them, that they do not agree necessarily with the father's decision to bring this motion, but historically and consistently, these parents have shown mutual trust and respect, maturity and cooperation, and exemplary parenting skills, both of them. Within weeks of separation in 2013, the father demonstrated enough confidence and faith in the mother that he consented to her relocating their 3 young children to another country. That's an undeniable vote of confidence in her parental judgment and responsibility. And despite the pot shots he has taken in this proceeding, he also acknowledged that she's got a lot of strengths and done a lot of things right. Just as she's always trusted him to be a responsible parent when the children come to visit him in Canada. They're good kids, and both parents deserve a lot of credit. In accepting the father's concern and hope that the mother should be as COVID safe as possible, the court also accepted the mother's reassurance that she is just as COVID safe as the father was. The court can't let the children get caught in the crossfire as parents engage in self-serving competition to show which one of them is more COVID safe. And the court can't certainly make decisions about specific children and specific parents based on media reports of ever-changing international COVID numbers and trends. We haven't reached a stage where an American parent automatically loses custody to a Canadian parent. It just doesn't work that way. Ultimately, the court declined to grant the father's motion and the 3 children to stay in Ontario with him. Among the many other reasons, the court emphasized that parents have a duty, especially in these uncertain times, to maintain stability in their children's lives. To grant this father's motion would be contrary to that objective. But as the court stated, but if one of the priorities during this health crisis is to try to keep children's lives as normal as possible, how could that possibly be promoted by suddenly uprooting them for everything they have known in the past 7 years? A new primary parent, a new home, a new city, a new country, new schools, new friends, new activities, new everything, and the loss of everything they know. Make no mistake, the court will have little tolerance for parents who either ignore or exploit the pandemic. But how can the court risk life-changing upheaval for these children on the basis of bald and uncorroborated allegations that the mother won't wear masks or engage in social distancing? Particularly where the mother categorically denies these allegations, and there's no evidence that she's ever been reckless in any respect of her life. So what do you think? Did the court get it right in this decision? You can like and share this video. You can subscribe by clicking the bell at the bottom. If you have any comments, please leave them in the comment box below. We're going to endeavor to answer everybody's questions and comments at the end of each week. Until next time, I'm Russell Alexander.